Right here.
Is that door open?
No.
All right, good morning. The first thing I want to point out is I don't think we're going to get through all the material that I assigned for today. So that means we'll be behind for next week. So I'm going to hold class on Friday as well next week. Not this week. Don't worry about that. Next week we will be here to get caught up, make sure we're on track. I have a couple of short assignments I need to start handing out. I'll start doing that next week. So I'll send out assignments to people. Excuse me. So that over the course of the next few weeks, everybody will have a chance to write out a short answer. Okay? Today, I have two problems that I didn't finish last time. I want to just talk about from the filing section, and then we'll move on and talk about relocation of the debtor. First thing I want to do is say, last week was like a miserable week for me. At one point, my knee hurt so bad I wasn't really able to walk. It was terrible. I went to the doctor, got a shot, big needle right in my knee. Yes, feeling a lot better today. So hopefully that will take care of it for me. It was just miserable last week. I went to a conference on Friday and Saturday. I wasn't sure I was going to be able to make it because I couldn't walk. Miracle steroid injection in my knee that made everything better. Okay, what I'm going to do is first talk about problems 55 and 56. Do those very quickly. I'll do a review of where the debtor is located, and then we'll move on and talk about relocation, and then start the material that you were assigned for today. So problem 55 asks what happens when the bank refuses to. Just for a second.
Let him know.
Video. We're not. Okay. I'll just stand over here. Portia paid off her loan and then the bank didn't terminate. What can she do? The answer is pretty straightforward. In the code, she can demand that they file a termination statement. If they don't, she can take her own action and file a statement to that effect, 509D2. What I think they want you to pay attention to is there are damages provisions in Article 9. So if a creditor does something, a secured party does something that causes harm to the debtor has the authority under 625 to go after them and get some money back. And there's two provisions in particular. You get actual damages, and there may be punitive damages as well under E4. So you can, if the bank does not take care of business, which they are legally obligated to do, you can actually get some damages here. And the damages you can imagine in this case would be there's a financing statement on file, but there's no debt. So now the person tries to borrow more money, and another bank's going to say, we can't lend to you because it looks like somebody else has a perfected security interest. And that's the harm, the inability to get credit. And maybe there's some follow-on harm that comes from that. So banks actually do this as a matter of routine. It's unusual for a bank to refuse to file a termination statement if the loan is paid off. Problem 56 says, that's 55, we jump ahead here a little bit. You have a bad actor filing an unauthorized financing statement. So it's a bogus filing, and in fact the problem alludes to the fact that these are actually have become fairly common, and it's a real irritation. You know, for most consumers, financing statements aren't that big an issue, but if they're filed against businesses, they're a huge problem. So there is a method to take care of that under 9518, but it is interesting to note that there are people who sit in jail and file bogus financing statements against prosecutors and lawyers and people involved in the case. And so they actually had to amend Article 9 to allow debtors the opportunity to fix the record, because there wasn't actually law that allowed that. So you had this tort of defamation that you could bring, but now finally we have 9/5/18. So those are pretty straightforward. I didn't think they were that complex. All right, so we're going to talk a little bit about relocation of the debtor, and I thought I would just take a second to review where the debtor is located. What happened there? Why did that go off the screen? Oh, there. Okay. So again, individual, it's easy. It's where you live. Principal residence, 307B1. Registered organization, state of incorporation, easy. Corporations, LLCs, limited liability partnerships, all of those registered organizations only have one place that they have a residence. You don't have to even think about it. You get the corporate documents, and wherever that state is, that's where you file. There are some organizations created by the United States. Again, it's the District of Columbia, unless there's a place designated in the statute creating the chartered organization. So they might have a location stated by statute. Otherwise, it's the District of Columbia. District of Columbia for the United States. If we have an organization that does not have organic records, so partnerships, for example, Chief Executive Office, 307B, and then organizations with Chief Executive Office in a non-filing jurisdiction. This is most often the last one. It's going to be a foreign corporation in a country that has no filing system for recording security interests. So the last one is the least likely to come up. Okay? But there is a rule, which is good. We know where to go. District of Columbia. So if you're looking at one of these and you're going, I have no idea, pick District of Columbia. You have a chance of getting it. If you can't figure out one of the first 2 or 3. Okay, so let's talk about interstate movement of goods before we get into the problems. We have 2 circumstances where the either the goods move or the debtor moves, okay? So here we have relocation of the debtor from state A to state B. And the statute says 4 months after a change in the debtor's location, you have to refile. So the circumstance would be Kentucky Corporation, let's make it an individual, it's easier. An individual residing in Kentucky has a filed financing statement. Where would that be? In Kentucky, right? Moves to Indiana. Right? So legitimately, completely relocates, now in Indiana. Where would we file? Well, if the debtor's located in Indiana, where do you file? Obviously, Secretary of State's office in Indiana. How long do you have to fix the relocation? Simple, okay? Now, the secured party has this obligation. It's not the debtor, okay? But what happens if the collateral moves? So the first hypo was the debtor moves. Now we have the collateral moving. Different period of time, 1 year. So this person is called a new debtor. Sorry, is the new debtor, right? A new debtor is now the owner of the collateral in a different state. 1 year to reperfect. Yeah.
How do the banks protect themselves? Because I mean, it seems like it'd be hard to keep track of all these people coming and going.
It's a great question. What do you think the answer is?
That they would put it in the security agreement.
Okay, it's probably a default. I agree with that. Yep, absolutely. But how do they protect themselves? Because it doesn't matter if it's a default, they still have to refile.
Just constantly
default allows them to foreclose. What if they don't know?
That's my question.
They're unperfected, right? So how do you protect yourself against that? There's no law. This is not a legal question. You're asking a practical question.
Right.
So what's the answer to the practical question? What do you have to do?
Just stay on top of all your.
Yes. You have to be aware of what's going on with your debtors. How do you do that?
Army of relationship managers.
You check the name on the check when they pay. It's hard. And I think that this problem comes up a lot. Hopefully, if it is a large transaction, there is a banker responsible for the debtor's business, and they get information. They do credit checks occasionally. They maybe Dun & Bradstreet sends them a report. They have a system in place for that individual who's responsible for that debtor is paying attention. For small debtors, they don't. It's just a risk, and they assume it. Okay, so you have to, if the secured party files in state one within 4 months, they're perfected forever, right? They've maintained perfection. It's a similar idea to the idea of lapse. Let's remember when we talked about how long is a financing statement good for? 5 years. So you got to refile within 5 years. It's the same idea. It's just you're now filing in a different state because of a move of the debtor. So as long as they refile within 4 months, they're perfected forever. I put these on line so you don't have to. Now, what happens if they file for bankruptcy? If the debtor files for bankruptcy? There's two kinds of creditors that we care about. Lien creditors and purchasers, i.e. secured parties. So if the debtor moves and a bankruptcy is filed before 4 months, are they perfected or unperfected? Is the secured party keep its perfection or does it lose it with respect to that creditor? Keeps it, yeah. The green line indicates perfection is still good. Lien creditors are not treated as nicely in the law as purchasers are, as secured parties are. So if the debtor moves and then files bankruptcy within 4 months, no problem. Perfection doesn't go away. Still perfected. And because it's the date of filing bankruptcy that creates the bankruptcy trustee's right to the collateral, that's the date forever. So they never become unperfected with respect to the bankruptcy trustee. They don't have to redo anything. It's all done. We'll study bankruptcy later to really understand this in greater detail. What if it's a purchaser? If you don't file within the 4 months, it's retroactive unperfection. It's as if you were never perfected. So for the lien creditor, there's no retroactive unperfection. It's all prospective. With the purchaser, it's retroactive unperfection. So the perfection, whatever it existed, just evaporates. And you now become an unsecured creditor as against that party. Okay? So you can have two people competing, a lien creditor and a secured party. The secured party might win because of the retroactive unperfection, whereas the lien creditor won't. If it's done, if that lien comes into existence within 4 months. And that's the purpose of these slides, okay? Okay. Let's talk about certificates of title. Again, certificate of title, easy rule. Where's it titled? If there's a title on the goods, it's the jurisdiction of where the title was issued. So we were doing some, now we're moving on to, we did a couple of them, I believe, 57 and 58, I think we already did, right? That's what I have in my notes. Am I corrected? Again, I was suffering from extreme agony last week, so I may have my notes wrong. Where did we end last class? Yeah, okay. So 59. Let's take a look at that. Now, we're talking about certificates of title. We talked about filing as well, so now we're moving on to the question of certificates of title. And, oh, sorry, no, we're finishing up the filing stuff. Yeah, sorry. Okay, so Factory Money is a legal partnership that has its only place of business in Chicago, where Octopus National Bank has its security interest. If the law firm makes a permanent move to Washington, D.C. on January 21st, does the bank lose its perfection? I'll leave that, yeah.
You would have the 4-month grace period to refile.
And why is that? Under what statute?
9316A.
Okay, okay. That's the move circumstance. If the debtor moves, what's the grace period? That's it. What's the grace period?
4 months.
4 months. Okay, so that's easy. Now, it's a partnership. How do we know where the partnership is located? Good. And that would probably be the location of the law firm. That would be easy. We don't care where the partners live. It's where the law firm has its main office. What if it merges with another law firm? Why is it a year?
I think it says the expiration of 1 year after a transfer of collateral to a person that thereby becomes a debtor and is located in another jurisdiction.
It's the new debtor situation, right? If there's a new debtor, so it's not if it's transferred to a new debtor, we have a 1 year grace period. Again, remember, the retroactive unperfection applies to purchasers. It's not retroactive as to the lien creditor. So the lien creditor's lien attaches within the 1 year. The original secured party 1, is still perfected. Everybody good on that? All right, question 60. Suppose that the Factory and Money of the Chicago law firm had 2 creditors before its permanent move to D.C., each of which had a perfected security interest. Octopus National Bank, which had filed its financing statement first, and Last National Bank, which had filed second, both creditors in Chicago in the year 2016. When a move occurred in 2017, Last National promptly refiled before March, but Octopus National was careless and didn't realize the firm had moved until September. What's the order of priority? What has happened?
Last National, or Octopus National become unperfected, so Last National takes over.
It becomes unperfected as of when?
As of this is the move, so it's 4 months after.
And what's 4 months after? The move was January 1st, right?
January 1st, so it would be first.
Okay.
March 2017.
January, February, March, April, May 1st they become unperfected. And it's retroactive unperfection or not? If it's a retroactive unperfection, who now is the perfected secured party on May 1st? Yeah, because they refiled they filed by March 1st, right? So they've got it within the 4 months. They've re-perfected appropriately. Therefore, the retroactive unperfection applies to them. They jump ahead. Does ONB become a perfected secured party in the new state when they file on September 1st? Sorry?
Would we know because it's past the 4 months they are unprotected?
Okay, but now they've filed on September 1st. Are they now a perfected secured party? Do they have authority to file that financing statement? Yes. 9509. Are they perfected on September 1st? Yes. Okay. They've lost their perfection. If they file a new financing statement on September 1st, they become a perfected secured party again, but their priority date has changed. It's effective only as of the date they filed against other purchasers. okay? And lien creditors that come later. Yeah.
I'm sorry, I'm confused. How long does that last? Is that based on like a factual investigation of, are they actually a secured party?
I don't know what you mean by how long does that last.
So say, OMB waited longer than the year, it's like, do they just lose their ability to be a secured
Well,
party?
whenever, but they, no, well, first of all, they're a secured party. They're always a secured party.
So if they came back 10 years after the fact and they realized, hey, we had this, we forgot about it, they would still be secured?
If there's a loan outstanding and they've got a signed security agreement, do they have authority to file the financing statement? They can file it anytime they want. Their choice about when to file affects their priority. Yeah. They can become perfected again, but their order of perfection changes.
But so for purchasers, retroactive perfection will
Yes.
kick in, and then they will supersede purchasers, but not creditors. If
Lien
they're-
creditor, make sure you use that terminology.
Lien creditors.
Lien creditors.
Okay.
Do the timeline, actually. it's better. Oh, it worked. Okay. So this is a timeline question, right? When did the debtor relocate?
January 1st.
Okay, so let's put ONB, and was it Second National or Last National, right?
Yeah, last.
Okay. So relocation, that's the reload date. Starts the clock running. How long do they have?
4 months.
Okay, so let's say that's 4 months. When does Last National file?
In September. Oh, excuse me. They promptly file.
Yeah.
Yeah, the end of March.
Yeah. Okay, and ONB files 9/1. As against secured parties, missing the 4-month date creates an unperfection that goes back and forward, right? It's retroactive unperfection for all time as against other parties. Now, they file on 9/1. Are they perfected again? So from this point forward, they beat later creditors, right? They beat later creditors, any later creditor. Now, lien creditor comes into existence here. Do they beat the lien creditor? LNB does, ONB does not. Lien creditor comes into existence here. Does ONB beat the lien creditor on, let's say this is 11/1. Does ONB beat the lien creditor comes into existence on 11/1? Yes, because they're perfected on 9/1. Okay, they lose to a lien creditor that comes into existence before they refile, but not this person. What if the lien creditor had filed here? So let's call this 1, 2, 3, LC3. Who does ONB beat? 1 and 3. Why 1?
One, because it's not retroactive, it only goes back into the 4 month, it only goes up into the 4 month period, but nothing before.
As against lien creditors, it's only from the point forward that their unperfection matters. Okay? Everybody good with this? They create this sort of window of opportunity for lien creditors to come into existence that take priority. Any perfected secured party beats them, but the lien creditors have to act after the relocation date. Sorry, it runs from here. After the reload date, up till when they get perfected next. Okay? All right. Okay. Moving on. Certificates of title. Problem 61. question is, truck is titled in, is it Pennsylvania, right? Oh, sorry, Indiana. It's titled in Indiana. Purchased in Pennsylvania, titled in Indiana. He told them a fake address. When Indiana law requires that the lien interest be noted on a certificate of title, when Sailor went bankrupt a year later, the trustee in bankruptcy argued that Ringer Truck was unperfected. Is that true? Because he did not properly ask for a certificate of title in the state where he was located. Does the location of the debtor have any relevance to where you perfect when there's a certificate of title? Everybody, I see a lot of people shaking their heads, which is excellent. What section tells us where you file to perfect a security interest in a titled piece of property? What section of the code do we go to? 9303, right? And what does 9303 tell us? 303A says, it's the law of the jurisdiction where the title was issued, even if there's no other contact with that jurisdiction. Okay? So that's the rule. Very straightforward. Does it matter that he lied? Does it matter he doesn't live there? It does not. That state issued a certificate of title, and the secured party recorded on that certificate of title they are perfected with respect to that property. Very straightforward, 9303A. Okay? So we don't, all the other facts that are in here, irrelevant. They're just red herrings. So, the Metzger case. Now what happens? Metzger, relocation of the debtor. Submits paperwork to get a new title. New title is issued without the recordation of the lien on it. Court says that a buyer under 9337, good faith buyer, does not take subject to that security interest. Again, 9337, very specific section. What do you have to be to win under 9337? And what does that mean to be a good faith purchaser? Let's take a look at 337. What's the language of 337? Now note, you said purchaser. Does it say purchaser in the statute? What does it say?
Buyer of goods other than a person in the business of selling the goods.
So section, comment 2. This section affords protection for certain good faith purchasers for value who are likely to have relied on a clean certificate of title. So between 1 and 2, secured parties and buyers take free of the security interest. And that's what Metzger says. What the statute says. Does it seem unfair to the secured party? A little bit. They didn't do anything wrong. They still lose. So let's take a look at problem 62. When Nick Dunn bought his wife a new car, he financed it through Flynn Bank, which recorded on the note. Before the loan was paid, Amy forged a letter to the Missouri Department of Motor Vehicles indicating that the lien had been released. She then moved, was it to New York, and sells it to her boyfriend, who has no knowledge. What's the doctrine that we learned in property law about forged deeds? Are forged deeds valid as against purchasers? They're void, totally void. They don't work. Is that what the outcome of this case is? No. What happens here?
The purchaser wins.
9337 happens. If you purchase it as a buyer with no knowledge, under 9337 you win. Now you have to give value, right? Isn't that what the statute says specifically? It says a buyer of the goods that takes free of security interest if you give value and receive delivery. All right, so just be sure you read that closely. It's not just a buyer who gives value and receives delivery. Right? But you can't know about the security interest. If you know about the security interest, you're not protected by 9337, which makes a lot of sense. Okay? So problem 62, even though it is a forged deed, it doesn't matter. Most courts are going to uphold that, and for us, that's the rule. Not really very fair to the secured party, is it? They didn't do anything wrong. This is a situation where the person who borrowed the money lied to the DMV. Shouldn't the bank be protected against that? Yes, but the system decided that good faith buyers should be allowed to rely on the certificate of title. And that makes sense, right? Because the certificate of title is the document that everyone relies on to make sure that the person who's selling you the car actually owns the car. So it's a decision that protects the system. How about problem 63? What's the difference in 63? Does the result any different? Why not?
It said to look at 9303B, and that says goods cease to be covered under certificate of title at time that goods become covered by the title in another jurisdiction.
Yep.
So it seems like who was the NCS, whatever, would have lost their, would not be perfected. I don't know.
Yeah, so let's just make sure we understand the facts, right? Holly drove the car to Dallas, and on the same day she re-registered it and received a Texas certificate. Somehow she was able to do this without surrendering the Oklahoma certificate, although Texas law apparently required her to turn it in. Texas required the lien interest to be noted on the certificate, but the Texas certificate showed no liens. She then sold it to her neighbor. Did the neighbor have knowledge of the pre-existing Oklahoma interest? Shouldn't be a different result. Okay? You can rely on the same title as the buyer. So that's a pretty straightforward rule, I think, and it makes sense. I don't think this is one that should upset anybody. I buy a car, I look at the title's clean, I'm good. Right? And I have no reason to check anymore. I look at the title and I'm okay. Now, I want to compare this to 9316D and E. Goods covered by certificate of title. This is D. A security interest in goods covered by a certificate of title which is perfected by any method under the law of another jurisdiction when the goods become covered by a certificate of title from this state remains perfected until the security interest would have become unperfected under the law of the other jurisdiction. There was an existing Oklahoma certificate of title. Why doesn't this govern? comments. Comment 5. This is why it's important to have a version of the code that has comments, right? Very last paragraph of comment 5. Section 9337 affords protection to a limited class of persons buying or acquiring a security interest in the goods when the security interest is perfected under the law of another jurisdiction, but after this date has issued a clean certificate of title. So essentially, 9337 is a special case exception to the 916 D and E rules. 916 D and E create a 4-month window of opportunity to get a new certificate, but 9337 always protects somebody who buys with a clean certificate of title. Okay, so just look at those comments if you're confused about how this works, but that's the 9337 is that special case. All right? So Natalie, you're correct, 9337. I just wanted to point out it's in the comments, and it makes it clear. All right. 63, 64, last one before we move on to the new material. Relocation from a non-title jurisdiction to a title jurisdiction. Bought a yacht in a state that did not use a certificate of title, moves to a state that does use a certificate of title for boats. So boats are a great example of there's a lot of differences between the states here. And the question is, does ONB's perfection in the second state last as long as its filed financing statement is still effective or for only 4 months? What did you conclude? Anybody? Volunteers? Remember, 9316 is the section that governs relocation. So what do? Is this a debtor moving to a new jurisdiction? Debtor relocates, and the collateral goes with them, and the collateral goes to a jurisdiction that has a different set of rules for how to perfect. Do you have to use the new set of rules in the new jurisdiction to maintain your perfection? That's what the question is asking. Yes. How long?
4 months.
Okay. Seems a little bit unfair because the boat seller was in a state that didn't have a certificate of title statute, and they may not know that the boat relocates. It's a risk assessment provision, right? Who bears the risk of relocation of the debtor here? Who bears the risk of having to re-perfect? It's on the secured party to do it within the 4 months. What if you go from a title jurisdiction to a non-title jurisdiction? So flip it. Armstrong never re-registers, doesn't get a new title in the new jurisdiction. So we're in a jurisdiction that has a title. Debtor moves to a jurisdiction that doesn't require a title. Is the perfection still good? You got an answer?
Yes.
And the answer is?
Your specific question?
Yeah.
I would say no. That they need to file in the new jurisdiction and possibly in Washington.
What section governs goods covered by certificates of title? (9303). What does 9303 say? This section applies to goods covered by a certificate of title, even if there's no other relationship between the jurisdiction under whose certificate of title the goods are covered and the goods or the debtor. So there's a certificate of title issued. 9303 says that section governs. B, goods become goods become covered by a certificate of title when a valid application for the certificate and the applicable fee are delivered to the appropriate authority. Goods cease to be covered by a certificate of title at the earlier of the time the certificate of title ceases to be effective under the law of the issuing jurisdiction, or the time that the goods become covered subsequently by a certificate of title issued by another jurisdiction. Is there a new certificate of title? So that second part of the sentence doesn't work, right? There's no new certificate of title. Is it not covered by the original certificate of title? Do the facts say that the original certificate of title is no good? So the original certificate of title is still good. 9303, it's still covered by the certificate of title. Okay? Non-title to title, got to get a new certificate. Title to non-title, don't have to do anything, because there's an existing certificate of title that covers the goods. Okay?
Would they still need to just file the financing statement?
Are they perfected? What is the method of perfection when there's a certificate of title issued? It's not a trick question.
Well, I mean,
What's
yes,
the, no, answer it.
the
You file on the certificate of title. See, I answered it. That was wrong. I asked you to answer it.
But if you move to a jurisdiction that doesn't require that.
Right. Exactly.
Wouldn't you have to collect in
You
that
already
jurisdiction?
have a certificate of title though. And under 9303, which is the same law in every jurisdiction, the rule is a certificate of title, if it is issued, is the system by which you perfect. And that remains the system until either that certificate is no good anymore, or there's a new certificate issued, right? Or there needs to be a new certificate issued. But in my second hypo, there's no new certificate. Remember the hypo I gave early on, where I had the company that was incorporated in Nevada and it was using trucks that were registered in Maine? Was there any problem with them being registered in Maine? No. What law governed the method of perfection? Maine. Doesn't matter. If a certificate of title has been issued and it doesn't go away, right, it's still a valid certificate, then that law determines how you perfect, which is you file on the certificate of title. Even though there is other rules about reperfection, certificate of title is an exception to that. Okay, 9303 governs. Yes?
Can you explain to me comment 4 from 9?
Probably not. Let's take a look.
Because I thought that meant that just because the perfection ended when it moved to a new state, that doesn't necessarily,
So comment 4 to 9303.
yeah.
Yeah. So the fact that the law of one state ceases to apply, okay, does not mean that the security interest perfected under that law becomes unperfected automatically. In most cases, the security interest will remain perfected. See 9316 D and E. Moreover, a perfected security interest may be subject to defeat by certain buyers, right? Okay, that's fine. But in the new state, what law governs how you perfect a security interest in a good that is subject to a certificate of title? The certificate of title.
So it doesn't, the fact that.
It will become unperfected if you go from certificate of title to certificate of title state, because you got to get a new certificate of title. That's absolutely right. The situation I'm proposing is one where you go from certificate of title to non-title state. There's no new certificate. There's no way the original certificate becomes unperfected. And the language I read out of 9303B says, until that original certificate is no good, it still governs. That's the rule, that's why. But it may be, you have to re-perfect if there's a new title that becomes issued, right? If there's some reason that this original title is no good, then you would have to, okay? And let me give you an example. Take a look at 9316, comment 7. So if you read towards the bottom of comment 5, example 7 to 9316, it says in the parentheses, for example, Illinois certificate of title statute may provide that the surrender of an Illinois certificate of title in connection with the issuance of a certificate of title by another jurisdiction causes a security interest noted thereon to become unperfected. So in that example, which is describing 9316 D&E, it could be that the law of the original jurisdiction regarding the certificate of title has rules about when that certificate and the perfection on it is no good anymore. If you have those facts, then yes, they would have to refile because they would become unperfected. And they would have 4 months. But if the certificate is still good and the method of perfection is still good, then they don't have to do it. Okay? Does that help?
Yeah.
Yeah, okay. So 9316 D&E work in conjunction with other stuff, okay? So 9316D says the security interest described in subsection D becomes unperfected as against a purchaser of goods for value, right? So there are purchaser protections, secured parties, okay? We have to read these together. This last problem in chapter 6, that's pretty high level stuff. Okay? Just want to point out. If you're sitting there going, that made my brain hurt, I agree. That requires pretty close understanding of how Article 9 works. So, the basic rule that you need to know. If it's a certificate of title property, so usually motor vehicles, you perfect by filing on the certificate of title. If it gets retitled, you have to re-perfect on the new certificate of title. If the second jurisdiction doesn't put the security interest on the new title, 9337, a buyer could be protected against that now unknown security interest. Yes? You're going to forget this the minute you leave here. What's the key? Know how to look up the rules in the statute. You're going to have the statute on the exam. You're going to have the statute in real life. Do not try to do this by memory. Look it up. And the key I want to tell you here is certificate of title goods have different rules. Know that going in. And maybe write in your notes in the code. Don't forget. Highlight. I'm cool with all of that. That's how real lawyers practice. They don't sit there and go, what did I, 15 years ago when I took this course. No, real lawyers don't do that. That's malpractice. I always look this up because it's just complicated. I get that. Learn how to use the code and go back and forth. Double check yourself. Okay? All right. Priority. We've danced around this all semester so far. Now let's talk about priority. Priority is literally this kind of dispute. 2 creditors. And we have 2 main kind of creditors that we have to talk about. And we have 2 sections of the code that we need to know. All right? That's it. Right now we're going to get, this is, the first few questions in here are pretty straightforward. We're going to start with lien creditors and move on to secured parties. The statute, the 2 sections of the statute that govern priority are these 2 sections as to these 2 kinds of lien creditors. Okay? The normal rule that all these rules are written against, that's the property rule. Okay? If we had no Article 9, it would always be first in time, first in right. That's the default. First in time, first in right. The rules that we're going to learn either continue that or vary it in some way. Okay? The reason this is important is we have a filing system. And so the ability to become first is modified by the ability to file a document. Okay, that's the key to this section. Why does priority matter? Priority matters because it determines who gets paid first. The number 1 rule for every bank that's lending money is to get paid. They don't care about anything else. Their only goal in life is to get paid. Their preference is to get paid every month according to the terms of the agreement. But when the debtor stops paying, sometimes they have to foreclose. Priority tells us who gets to foreclose first. So in all of these battles, there's probably, the only people who can't foreclose are unsecured creditors. Everyone's entitled to foreclose with these competitions that we're looking at. Everyone has a security interest of some kind, right? A lien or a secured party, security interest under Article 9. If you're unsecured, can you foreclose? If you're unsecured, can you foreclose? No! Being unsecured sucks because you got nothing. Being unsecured means you're relying on the promise of the debtor that they're going to pay. And that's your only security, their bare promise to pay. In every competition we're looking at here, all of the creditors at some level have a right to foreclose. It's just who gets to do it first that we're talking about. That's what priority is. Okay? The battle between a secured party and a lien creditor is 9-3-17. The battle between two secured parties is 9-3-22. Two sections tell us who wins. We're also going to look at some variations on this for special kinds of creditors. So the big one we're going to look at today, if we get to it, is the purchase money secured party. We like purchase money secured parties more than the average creditor, so we give them special protections. So let's do the first problem, because it should be straightforward. It goes up in complexity. Problem 65 asks. All right. Let's see. Why don't we start? Sam, how are you?
Good.
You're really unhappy
I
to
was
be.
good.
It's like I happened to look down, your name jumped out of the paper. This is a straightforward question, so take a second. There should be a pretty straightforward answer to this one. The book is trying to start us off with the basics, okay? Who are the two competing secured parties? The two parties that are competing, what are their names?
ONB and Martin's Travel Service.
Okay.
And ONB signed a security agreement, but never filed a financing statement.
So, in order to be perfected, what are the 4 things we need?
Value, rights, agreement, attachment.
No, that's attachment. Value rights agreement, that's attachment. Security interest has attached. What's the 4th thing we need to be a perfected secured party? Well, usually filing, right? A method of perfection. Are they a secured party?
No, because they don't have a method.
Well, no. Are they a secured party?
Yes.
Attachment occurred, so there's a secured party. Can they foreclose?
Yes.
Yes. If you're a secured party, you're allowed to foreclose. You don't have to be perfected. Perfection is a priority battle. You can foreclose. Who gets to foreclose first? That's what we're asking here. Did they file a financing statement?
No.
So who are they up against?
An unpaid, or Martin's, which looks like, I don't know, it doesn't say if Martin's is. Does it matter if they're, I guess it does if they're secured as well, but it doesn't say that in the facts.
Okay. Martin's Travel Service was an unpaid creditor of the bookstore. Can they foreclose if they're unsecured?
Only if they get the sheriff involved.
They get a lien, right? Yes. Can they become a lien creditor? Do they become a lien creditor?
It looks like they,
Again, this is all timeline, right?
Yeah.
So we're talking about ONB against, what was it? The travel company?
Martin.
Martin, right? They have value rights agreement, but we don't have a financing statement. So they're a secured party. Now, Martin has filed suit, won a judgment. What do they need to do?
Have the sheriff, levy on the
Right.
inventory.
Exactly.
That's the only way they can recover.
Right.
themselves.
So let's say Martin gets a levy on this date. What set of rules do we use to determine if O and B wins the priority battle? What's the section of the statute?
It says 9102 on here.
Well, that's the definition of lien creditor.
Uh,
That's the definition section. What's the priority section? 9317, great. When does a lien creditor beat a secured party? Or let me flip that. When does a secured party beat a lien creditor? So if that's the date of levy, what has to happen? They're already a secured party. They've given value rights and agreement, but they have not filed. In order to beat the levy, what do they have to do?
File
They would have to file here, right, before the levy. Have they filed yet?
the,
So, what's your advice, right? That's the question. Who wins as between a lien creditor and a secured party? 9317A2. What does 9317A2 tell us?
if the person, or I guess the lien creditor wins. then it's-
If they get their levy before,
Before the security interest is perfected.
all right, not perfected, or, that's right, that's the first part. The levy before the perfection, they're not perfected. What's the other one?
And the filing, and the financing statement is filed.
So there's interesting. Filed financing statement plus one of the 9203 things, isn't that what it says? Yeah. So there's two ways for a secured party to beat the lien creditor. Be perfected. Well, that makes a lot of sense, right? If you're perfected first, you should win, obviously. Or you file first and something else has also happened. One of the 9203 things has occurred. Right, 9203B, right? What is the 9203B thing that probably we're looking for? Any guess? Well, no, perfection, if you perfect first, you win. Right? That's 9317A2A, I think, right? What does 9317A2B say? Secured party wins if.
One of the conditions.
It's attachment.
Okay. But if you're attached and and you have a file financing statement, are you perfected?
Yes.
Okay, so it can't be perfection because you always win if you have perfection. So 9317A2B says what?
As long as one of the conditions of attachment is met, plus filing of a financing statement.
So it's not enough that you have a file financing statement. You have to have something else happen, and that's value rights agreement, right? Okay? 9203B. You're not fully perfected, but you have a filed financing statement, and you're on your way to becoming perfected. Then you beat the lien creditor. Okay? For example, let's say you have a signed security agreement, but you haven't lent any money. Are you a perfected secured party if you haven't lent any money?
If you,
Are you a perfected secured party if you haven't lent any money? No, because you haven't given value. So you're not perfected. But you've got a signed security agreement and a filed financing statement. You beat the lien creditor. Okay? That's the essence of this. Get your piece of paper on file and do something else, and you're perfected against the lien creditor. Right? It's usually going to be the signed security agreement.
Do something else?
Yeah.
Just
One of the
three?
one. Yeah.
Okay, I didn't know if you had to do all of the three or just one.
No. If you do all of the three and you file, are you perfected?
Yeah.
Yes. So 9317A2 perfects the unperfected secured party.
If you just do one.
Yes. The key is file financing statement. Now, if you file a financing statement early, and then there's a lien creditor, but you haven't lent the money, you haven't signed a security agreement, you haven't done anything, do you beat the lien creditor? No. That's important. It's different than 9322, we're gonna see in a minute, okay? All right. But filing the financing statement early and doing some other stuff protects you. So that's probably the security agreement. Okay? We all good on that one? There's a lot of time on that one, but that one's important because it's the one against which all are they're assessed. Okay, problem 66. So Natalie.
Okay, so Coke Travel Agency failed to file a financing statement, that they'd authorized because the attorney lost a statement. And then Bentham National Bank did file a financing statement in the proper place. So I put that Bentham has priority because they perfected their security interest.
So what is the rule that we look at?
322A2 and then comment 3.
So we have, is Coke a perfected or an unperfected secured party?
They're unperfected because they didn't file.
But are they a secured party?
No. Well, yes.
Three things. Value rights agreement. Do we have all three? Has the debtor lent the creditor lent money?
Yes.
Does the debtor have rights in the collateral?
Yes.
Is there a security agreement?
Yes.
Secured party. Did they file a financing statement?
No, not properly.
So are they a perfected secured party? No, but they
No.
are a,
Secured party, yeah.
so they're an unperfected secured party. What does 9322A2 tell us? A perfected secured party beats?
The unperfected secured party.
There we go. That's a simple rule. Unperfected secured party always loses to the perfected secured party. Always. We don't care when anything happens. Time is irrelevant. Right? We're in the black hole. I was reading an article about physics earlier. So. Unperfected secured party loses to the perfected secured party. We don't care when anything happens. That's just the rule. So, first in time, first in right, don't care. This is one of those rules that changes the first in time, first in right rule. Who's first in time? Coke. They got their security interest first. Can they foreclose? Yes, they're a secured party. If the debtor defaults, they can foreclose. Who gets to foreclose first?
Bentham.
Okay, that's it. It's that simple. Unperfected secured parties always lose to perfected secured parties. 9322A2. Be nice if I actually had the statute open, right? So if you're making notes to yourself, 65 and 66 are the two things that you need to compare. Okay? In terms of unperfected secured party can beat a lien creditor under certain circumstances, but can never beat a secured party ever. 9322A2. The unperfected secured party can beat a lien creditor, but can never beat a secured party. And that's the difference between 65 and 66. And if you struggle with that, talk to me, because that is critical, okay? I can guarantee you, 100%, I will ask a question on the final exam that has some kind of variation of this, okay? This is what this class is all about. These two questions. It's the start of everything in terms of the exam. It's always about priority battles. That's the essence of secure transactions. Who gets paid first? That's all we care about. And we're talking about methods of getting paid. All right, problem 67. Now, This has multiple subparts. So the first question, do both parties have a perfected security interest?
Yes, because according to the lecture, First National Bank can pre-file,
Okay.
so they get the interest there, then they loan the money on November 10th, but in between,
I guess the question's a little simpler than you're answering. Did both banks have a perfected security interest, assuming they filed in the proper place? That is it possible for two creditors to have a perfected security interest in the same collateral? Yes! Can there be two mortgages on a house? That's the same question, just a different kind of security interest. Yes, there can be multiple perfected security interests in the same collateral. That's what the first question is asking. There's a priority battle, but they both get to foreclose and they both are perfected. Okay, now, you seem to want to answer the next question,
I
so.
really don't want to answer that question, but I'll give it a shot.
Okay.
First National Bank would have priority
Why?
because they pre-filed.
And where do you get that from?
I think it says, is it in 322?
It is! Lien creditors are 9317, secured parties are 9322. Battles between them, right? Battle between the secured party and the lien creditor, 9317. Battle between the secured party and the secured party, 9322. We've already done perfected secured party against unperfected secured party. Are both of these secured parties perfected? Yes, they've done all four things. Who wins?
First National.
Why?
Because they perfected.
Well, that's one way to perfect first. That's one way to win.
They filed first.
Okay. What's the rule in a priority battle between two perfected secured parties? First to file or perfect. First to file or perfect. 9322A1. As between two perfected secured parties, first to file or perfect. As between two perfected secured parties, who wins?
First to file or perfect.
Yes! First to file or perfect.
First file or perfect.
Oh my gosh, this is so critical. Sorry, I'm not making, you're all doing a great job. I'm trying to emphasize this. First to file or perfect. Now understand what that means. If you're the first to file, but you perfect later, do you beat the earlier perfected secured party? Yes! The date you file your financing statement is the date of your priority in a priority battle against a secured party. 9322A. If you file and do nothing else, do you beat the lien creditor? You file, but you do nothing else.
One day.
Yes. 9322A1. First to file and perfect. 9317A2. First to perfect or first to file and do something else. There's a little bit more that has to happen to beat the lien creditor. It's not enough to merely file. Okay? Yes?
Is there a difference between superior right to inventory as opposed to like superior priority?
No, I think they're just meaning priority. Yeah, superior right. It's the who has the right to foreclose first. Yes, that's the superior right we're talking about. Okay. Exciting stuff. Why would we pick first to file as a method of determining perfection?
Notice.
Yeah, it's a notice filing system. If you have two lenders competing for the same collateral, we tell them search and don't lend if there's somebody else out there. And we don't care if you know if they don't have anything, they always beat you if they file first. Yeah, go ahead, what's your question? This is why you pre-file. Okay? Pre-filing establishes your priority date against other secured parties. Pre-filing does not help you against the lien creditor unless you have something else. But it always beats every other secured party.
So if they had taken possession and perfected that way before somebody filed, the person that had possession first would win?
First to file or?
Perfect.
Yes. So if you can predate perfection to the filing, do you win? Yes, that's what the statute says. Exactly. So, what would be a method of perfecting that where there's no filing? Possession, great example, right? We also have control. That's another one we'll study a little bit later. Automatic. There are other methods of perfection. And PIMSy, purchase money security interest, have relation back dates. But you don't even have to worry about that yet if you don't get this, because you got to get this. That's why I'm spending so much time on it. Now we have 4 minutes. Let's finish this problem up. And this is why I want to come back on the 11th. Obviously, next week on Wednesday, we're going to finish this up and start the next material, and then we'll finish the next material on the following Friday. Okay? So no class this week, next week, Wednesday and Friday. Okay, part C. If either bank had knowledge, does knowledge matter? No. When the drafters of the code want someone to have either knowledge or no knowledge, they will put it in there. 9337, right? Do you get the protection of 9337 if you knew that there was an existing security interest even though it's on a clean title? No. You have to take without knowledge. Is there any mention of knowledge in 9322? None. Don't care. Doesn't matter. Filing, right? You could sit there as a bank and go, they didn't file! Quick, let's run out and file! And you win. Does not matter. Suppose First National Bank had filed its financing statement before the debtor had signed the security agreement. You want to try this one?
I said.
I've picked on you guys a lot over the last few weeks, so I apologize.
I
I'm going to
said-
move back over there.
I said S&B wins because the agreement did not perfect, there's no agreement for First National Bank.
Okay, so this is referring you to who has authority to file a financing statement, right? When do you get authority to file a financing statement?
After a security agreement?
Correct. What's that referred to as? Does anybody remember? Ipso facto authority. If the debtor executes a security agreement, ipso facto, the secured party can file a financing statement. Did they have a filed security agreement when they filed the financing statement?
No.
No.
one didn't.
If you have no signed security agreement, do you have ipso facto authority to file? So it's an unauthorized filing of a financing statement. Did they later get a signed security agreement?
Yes.
Okay. Does that fix the problem?
No.
Oh, so close. Because it's yes. You can have retroactive ipso facto authority. Did anybody see in the comments where it says that? Look at official comment 4 to 9322. I think it's the, where is it? I forgot to highlight it. It says here, affording priority, first file applies to securities that are any method. Oh shoot, where did it go? Under a notice filing system, a filed financing statement indicates to third parties that a person may have a security interest. With further inquiry, they may discover the complete state of affairs. So this is paragraph 1, 2, 3. When a financing statement that is ineffective when filed becomes effective thereafter, the policy underlying the notice filing system determines time of filing for purposes of A1. For example, the unauthorized filing of an otherwise sufficient initial financing statement becomes authorized, and the financing statement becomes effective upon the debtor's post-filing authorization or ratification of the filing. Not only is it first to file or perfect, It doesn't even have to be authorized at the time of the file, as long as it's authorized later. Retroactive ipso facto authority. Write that down. You're going to graduate from here and you're going to say to somebody, the best thing I ever learned in law school was retroactive ipso facto filing authority. For me, it was non-mutual offensive collateral estoppel. Love that phrase. Non-mutual offensive collateral estoppel. Greatest theory ever in civil procedure.
So I hate to ask this question at the 11th hour, but like, so say they,
11th hour plus 1.
so say they pre-file and they end up not getting the security agreement down the line.
If you're not a secured party, can you foreclose?
But like my question is, do they have an obligation to terminate that?
Oh, sure, yes, absolutely. Yeah, if it's filed without authority, it has to be released. Yes. Yes. They never end up getting a loan, the bank has to release it. Absolutely. Yeah. Now, they might say, hey, but we're still negotiating. And then the debtor will be like,
What's that early
"Don't
class
care,
you
get rid of
have,
it."
Kelsey? What's that early class you have? Oh,
First, as you're packing up, first to file or perfect
yes.
always wins 9322A1.